You should be live now.
Good morning, Senate Judiciary, February 9th, 2021. Welcome. We have with us this morning to deal with S18, 3 witnesses scheduled, and then we'll have committee discussion. It looks like we're trying to crowd all 3 into 15 minutes on the agenda, but that was a little typo. We have former Senator Debbie Ingram of Chittenden County and Fran Carlson, volunteer with Vermont Interfaith Action, joining us first, and then we'll hear from Monica Weber, who works for the Department of Corrections and is Director of Administrative Services. So, welcome back, Debbie. Nice to see you.
Thank you very much, Senator Sears. It's very nice to see you, and I appreciate the opportunity in my return to my old role to be able to speak to you. It's good to see all the senators. Thank you. I have been the executive director of Vermont Interfaith Action for 14 years. So even during my 4 years in the Senate, I continued in this role. And our organization is about working with everyday folks at the grassroots level to try to affect systemic change around certain issues. So I've been working with a group of people, mostly from St. Paul's Cathedral, the Episcopal Church in Burlington, around corrections reform for several years now. And it's come to our attention. We've been speaking with especially women who've been at the Chittenden Regional Correctional Facility in Chittenden County, about their experience being incarcerated. We're actually currently in conversation with a woman who is at CRCF now, and we've spoken with others who have been released. But one of the things that they have really asked for is compassionate release for those who have had serious medical conditions, those who are advanced in age and have served most of their sentences. So that's what we went to Senator Bruce and spoke with him, and he indicated that there might be an amendment to this particular bill about earned good time that would expand compassionate release. I know there's one bill that was passed in 2018. And there was an attempt last year in the Senate to expand compassionate release. And we are hoping, Vermont Interfaith Action is hoping that you'll take this up again and show some compassion to these inmates who have served most of their sentences and have had very serious medical problems and are now older and would really benefit from some compassion from society. So Fran is going to read a statement it's on behalf of our whole group. VIA represents about 15,000 Vermonters all over the state. And so I'll just turn it over to her.
Okay, thank you very much. So Vermont Interfaith Action would like to speak in support of expanding the opportunity for those who are incarcerated to be released through parole or furlough if their combined age and medical condition warrants such a release. Vermont Interfaith Action VIA is a faith-based grassroots coalition of 68 member and affiliated congregations throughout Vermont that work together to effect systemic change around issues of social justice. We represent about 15,000 everyday Vermonters who care about their friends, families, and neighbors, and try to make compassion and justice a reality for those who are most in need. Our congregations are from Protestant, Catholic, Unitarian Universalist, and Jewish faith traditions. And we have individual members who are Muslim, Hindu, and Buddhist. One of our local organizing committees, composed mostly of Episcopalians and Presbyterians in Chittenden County, has been advocating for compassion and justice in Vermont's correction system for the past 6 years. In addition to our longstanding goal of trying to improve preparation for release for those who are incarcerated, It has come to our attention by speaking with currently and formerly incarcerated individuals that Vermont's current provisions for early release for those with medical conditions could also be improved. Persons who have or have had cancer, heart disease, or other serious and chronic illnesses, and who are at an advanced age are at low risk to public safety if they are released so that they can continue treatment or simply convalesce among supportive friends and family in a home setting. In addition to showing empathy and humaneness to these folks, this practice has the added benefit of freeing up beds in our facilities for riskier inmates and of saving the state money for their care. Debbie Ingram, who has spoken so wonderfully there, our executive director, has been corresponding with one of these incarcerated women over the last couple of months. This woman, whom we'll call Sylvia, had a bout with lymphoma during her 17-year sentence and was at first hopeful that Act 91, originally H-150, enacted in 2018 would help her. She was disappointed that it did not. Then last year, Sylvia was hopeful that the Senate proposal for compassionate release would make it through the House as well. She was disappointed that that did not. Now she's once again hopeful that she can get a chance at compassionate release. She wrote this to Debbie recently, quote, "DOC made it plain that since I am functioning and in remission from the cancer, I am fine. Maybe on the surface, but as an elderly inmate, ugh, with 85% of my men served and an uncertain medical future, I think age, time served, low risk language is needed in a bill. I am sure there are males in this category and others, both male and female, will be in the future. It could save the state money and free up beds for inmates out of state. This was the original purpose of H-150 in 2017, and according to an article in the Free Press at the time, there was no opposition, and even the Commissioner of Corrections at the time, Lisa Menard, concurred. This is what I hope to see introduced and passed," unquote. As people of faith, we at VIA respectfully ask that you find it in your hearts to show compassion to those who have made terrible mistakes, but also suffered from illness and advanced age. We believe that everyone is more than the worst mistake they have made in their life, and that when they are no longer at risk to others and are suffering themselves, it will reflect better on our society to show them some compassion. Thank you so much for listening.
Thank you. Are there any questions for either Fran or Debbie? Senator Nickton.
What is the advanced age that you are recommending?
65 is what what was in the original H-150 that I believe Representative Molly Burt introduced back in 2017, and that was what we were thinking.
Thank you.
I think that was the age of the amendment we passed last year in justice reinvestment that was taken out by the House. 65, but I could be corrected. Senator Benning has a question, then Senator White.
So Fran or Deb, I'm not sure which one of you would answer this, but a 17-year minimum sentence for Sylvia indicates to me as a criminal defense attorney that was a serious charge initially. You had indicated that the commissioner was okay with it. You said somebody else. I'm wondering if the victim in that particular case or victim's family, depending on what the actual crime was involved in that conversation.
I'm not aware, Senator Benning, whether the victim has been, victim's family had been contacted. You're right. I mean, I know that's the difficulty of your decision, is balancing the needs and the rights of victims and their families, and making sure that justice is served for them with the compassion towards these folks that have done terrible things. So I certainly you've put your finger on what's the really difficult balance to strike here.
So what is your thought process about the victims actually becoming involved in that conversation where a compassionate release might be the subject for discussion?
Well, I mean, they would still, the folks that we were talking about in this legislation would still have to go before the parole board. So I would hope that there would be time in that process to contact the victim's family and to get some input from them.
Senator White?
I don't have a question. I just wanted to apologize to Debbie for being late.
No, that's all right. Good to see you, Senator White.
I appreciate both of you coming forward. I think I spoke with Eric. We would probably consider the amendment that passed the Senate last year, as I don't remember all the details of it, to be totally honest with you. But it seemed to make sense to this committee and to the Senate last year, but the House refused to concur. It was part of the Justice Reinvestment 2 bill that passed. So we had already kind of discussed this with Senator White. She's been pushing for this for years. And I think your points are well taken, Fran. I appreciate it. Do you have a copy of your testimony that Peggy could post on the committee website?
I sent it to Peggy.
It's
Oh, you
posted.
did? Okay. Oh, okay.
It's
Oh,
already
I
posted.
checked earlier, Peggy, and I didn't see it, so
Yep.
thank you. Any other questions or comments for either Debbie or Fran? Thank you both for joining us. Good to see you again, Debbie, and good luck with all that's going on with both of you.
Thank you so
Appreciate
much.
Very
you
much.
being here.
Yeah.
Bye now.
Bye
See you,
now.
Debbie.
Our next witness is Monica Weber, Chief, your title, Monica. You had it
I'll
written
give
down
you
here.
my title, sir. Thanks.
Director of Administrative Services for the department, but it's kind of a catch-all phrase to somebody who provides us with guidance and help throughout the justice reinvestment process. So Monica, you had some.
Yes. Thank you, Senator. Good morning, committee. For the record, Monica Weber, Administrative Services Director for the Department of Corrections. Yeah, I have a different topic that I wanted to bring to your attention. As you all know, we are implementing good time based on the emergency rule. And I think I might have mentioned in previous testimony that as we go through implementation, we may come back with some minor suggestions or requests around how we could modify and make some of the statutory language a little bit more clear. And so the request that I have for you today is coming in that vein. And we are asking that language be added to this section around who is eligible and who therefore would not be eligible to exclude people who are serving an interrupted sentence. Meaning they might come and they might be on, in this example, I'll be really clear, people who are sentenced exclusively to serve a number of days on work crew. And they may come in and serve a day and then come a week later and serve another day. That's what we're referring to as an interrupted sentence. Those people are not under our continuous supervision. They are supervised for that day, for that time period. And in our previous version of earned reduction of term, which maybe some of you are familiar with, I was not with the Department of Corrections at the time. I understand it was a complicated system. This group of people were excluded from receiving an earned reduction of term. Again, you know, the way it's put together, it's you serve for a month and you get credit, you know, for whatever days you served during that month. But most people are under the continuous supervision. And in this case, it's a little bit different. So I'm happy to answer questions about that, but that's our request to
So
you
I have
at this moment.
Well, actually, a couple of questions arise. If we do this, there's some people that get sentenced for weekends. Would they be in that category as well?
Technically, they would be in the category if you said interrupted sentence, and it is our request that you would include them as well. We are having our main issue is around people with work crew, but if you said interrupted sentence, it would include those weekend sentencers as well.
Okay. Does this impact, and another issue now that we're bringing up, the certain statuses, does this interrupt anybody who's on work crew? I don't know if we still have much left at St. Johnsbury of those that work outside, but anybody who is sentenced to the.
So there's a difference between work
They
crew.
they've been getting a week all along,
Yeah.
a week
So
per month. So.
People who are at the work camp and if it's non-COVID times, be leaving the facility and doing going out on a work crew with a work crew leader, but they come back to the camp, they get work camp good time, and that's a different set of good time. They get day for day, right? And that's in 28.811. The group that I'm talking about are people who are in the community. They would only be under supervision for the day they would show up to, one of our field offices or to an actual site, perform their work crew, and then at the end of the day, they go back to, their homes or wherever they're living, and they proceed with their lives until they come back to the next day of work crew that they serve, right? So it's a different group of people.
So, yeah, okay. Is this well defined?
Is it? Yes. You could even make it much more clear around specifically interrupted sentences for people who are sentenced only to work crew. I think it depends on how you want to put the language in there, but it could be very well defined.
Are there many of them right now?
I don't know the answer specifically how many people, because of course, the work crews are not really operating the way they are at the moment. However, if you're technically, they're eligible to serve, and if they're
well, the argument's been made that somebody that's already sentenced is eligible for good time starting January 1st.
Correct.
And then the Defender General has made clear that he plans to, if we pass a bill, he plans to sue on it. And I'm just wondering if they're collecting the credit now and we have an issue there as well.
That's a good point, and we'd certainly have to look into that. People aren't able to serve those work crew days at the moment because we aren't putting work crews out in the community.
So there may be nobody getting it right now. Okay. I don't have any further questions.
Yeah.
Eric, is it clear to you in terms of drafting something?
I think so. I did. It wasn't until the very end there when, and I can certainly run the language by Monica, but did I hear you right that at first, just looking at what you had mentioned, I think in an email as well.
In the email, yeah.
Yes, something along the lines of, we'll add to that exclusion list, offenders who are sentenced to serve an interrupted sentence.
Yes, that's what we were asking. Yes.
Okay. So it doesn't necessarily have to be specify work crew. It does
not. And work crew is technically not a sentence. It's a program. They're sentenced to a treatment furlough. So.
Oh, okay.
Yeah.
Okay.
So interrupted sentence is a language that would work for us.
Thanks.
Senator Nitke, did you have a
Just
question?
trying to figure out the exclusion of those persons, but I was wondering with regard, so Monica, you said they show up and work one day and then they show up again the following week. Is it that they're not showing up for the days they're supposed to show up for? Or they just simply are scheduled to come one day?
I'm sorry. Yes, I can be more clear. Sometimes the schedule is that it's one day a week. Sometimes they'll have 5 days and they'll go 5 days a week. Oftentimes it's just the schedule and how many days that they have to serve.
Thanks.
Yes, you're welcome.
Senator Baruth.
Thank you, Ms. Weber. I'm wondering, on an unrelated topic, I'm taking the opportunity to ask corrections folks when they come in about the status of the driver's licenses for parolees. And when we had Dale Crook in, I asked him if he could give me an email update. He said he would, but none has surfaced. Can you tell us anything about that?
Yeah, well, one thing I can tell you is that the person who is our lead in the program was out last week, and she is aware of your request, and we're working on a response to provide back
Okay.
to you. So I do apologize for the delay, but we have not forgotten about your request, and you should get some information soon.
Perfect. Thank you very much.
Yes, you're very welcome.
Further questions or comments for Monica? Okay. Thank you, Monica.
Thank
All
you all
right.
very much.
I'm going to,
Senator Sears?
yeah.
Can I just thank Monica for always being so kind of clear and concise and not adding a lot of words that don't need to be in there? Thank you.
Yeah, that's great.
I do my best, Senator. Thank you.
S18. Why don't we start the discussion? Eric, if you could join us.
Yep.
There's been a lot of suggestions, but I believe we've got about 4 or 5 amendments to consider.
I'm going to run upstairs and get my folder. It's in
Okay.
the space.
One of those amendments would make clear notwithstanding language.
Right. That's the notwithstanding 1 VSA 214, which is the retroactivity
Right.
provision of the Vermont statutes. The idea there being that you want to ensure going forward that that the change, assuming that it goes forward with the change to the folks who are already incarcerated, their
Right.
ability to earn good time going forward, that isn't inconsistent with the language that you already have in 1 VSA 214. And that's something that it's not uncommon for the legislature to do when they want something to apply retroactively. Remember, you did it last year with respect to the child sex offense crime. So yeah, you'd want to have that notwithstanding section 214.
Right.
As you
Eric?
mentioned, Senator Sears, that there still might be constitutional issues going forward, but I think the committee's already heard about that.
Sorry, I just wanted to ask, on page 2, we already notwithstand subdivision 1. So I understand you could have more than one notwithstanding in a bill. I just wanted to be sure that in my own mind about how those two would interact.
I think you're right that it would be notwithstanding both pieces. Yeah.
Okay,
So it would be notwithstanding this other pre-existing section of the Vermont statutes that's elsewhere, as well as notwithstanding anything that's previously said right there in that subparagraph 1.
okay.
Yep.
Could you put the new notwithstanding in that same section?
I think so, yeah.
Okay.
Yep.
Wait a minute.
The second amendment that we discussed was changing the name to something like earned time, dropping the word good.
Yes, that's right. So each time in the existing statute, we'll change the name entirely to the earned time program.
Yep.
Okay.
Third amendments have to do with victim notification, I believe.
Yeah, I haven't heard from Sarah on that yet. I don't I see you're on the witness list. I think they were going to send some language on that.
I think they may have. I think I got some.
Dick, can I ask you a question?
Yep.
Have we come to a decision about which crimes are going to be disqualifying?
No,
Okay.
that was my next.
Oh, I didn't want to. Okay, thank you.
I had proposed that, I think I proposed it, and there was some confusion about it. 'Cause I had a number of emails from people on the 2602 lewd and lascivious conduct with a child. I had proposed having A2, little A2. The section shall not apply if the person is less than 19 years old, the child is the somehow that people who were convicted of that crime of guess it would be statutory rape. Correct, Eric? I
Although
wanted to
it-
discuss how to deal with that group.
Right. The
'Cause I
age gap
don't-
group.
Yeah, I don't know if we really want to change the age gap and get into all of that, but is there a way of exempting if that was the sole reason for the conviction?
Yeah, I think that age gap, again, you still have the policy decision of whether to include L&L with a child, but assuming you do, then that age gap kind of goes along with it. So a person who falls within the age limitations that you just mentioned, Senator Sears, that if the person is the offender's less than 19, the child is at least 15, that person couldn't be charged with L&L with the child anyway. So
I wanted to expand that to
a broader range,
for the purposes of this.
right? And you mentioned too, and I'll just because I followed up on this, you do that same thing. You expand it a little bit for purposes of the sex offender registry. So for the registry, for example, the age gap is a little broader, and I believe, let me just pull that up for you. It's the child is at least 12 with respect to the sex offender registry. So in other words, the person could still be charged with L&L with the child. Let's say if the child was 14, would still have the criminal offense as a possibility,
Right.
but they would not be on the registry. So in other words, it's almost like you've widened the gap for purposes of a collateral consequence, not for purposes of the underlying offense.
And
And that
I would like that same
Yep.
gap being there for the purposes of earning good time. So if the person was 30 years old and had a sexual relation with a 14-year-old, I don't think they should. But if the person was 17 and had a relation with a 12-year-old, 13-year-old,
Yeah,
this is only for the purposes of earned time.
right.
right doesn't change the underlying offense.
Is if you have a 22-year-old who exposes himself on a playground with a bunch of 6-year-old kids, that's lewd and lascivious, right?
Does not qualify for this offense. No,
No.
not the way I read it. That is lewd and
But no.
lascivious conduct, which is a separate offense.
This
That
is
person
lewd and
could-
lascivious for the
I'm talking
child.
about it would be considered lewd and lascivious conduct under 2602.
No, I don't think so. Because of the language in 2602, which is different than your straight lewd L&L statute, says, if you're looking at the language now, says upon or with the body or any part or member thereof of the child. And the cases seem to require some physical contact between the offender and the child.
Oh,
Now, that's not, if it were a straight L&L charge, which is different, that's 26, I think 2601, I believe. But yes, you would be right. If that person exposed themselves, they could be charged under that different statute, but not this one. This
okay.
requires some physical contact.
Oh, thank you.
Yeah.
And then obviously the compassionate release would be an amendment, and then the amendment that Monica just posed.
The compassionate release as it passed the Senate last year?
Yeah.
Right.
Are there any other that I missed?
That's all the ones I've got, other than the list of offenses itself that we were going to get to last, but I think that's everything else.
Well, we hadn't settled the question of whether it would be retrospective, prospective, or both.
That's right. Thanks.
How was
Yeah.
last year's? Was that retrospective?
Good time?
Yeah.
Yeah, we wouldn't be here if it wasn't.
Okay,
I mean, the section that allowed persons who were already convicted of
Right.
these crimes to begin accruing good time. So we can start anywhere you want, but maybe we should start with the easy one first.
can I ask a question first?
Yep.
So when they were charged, that was retrospective, but they didn't earn good time for all that time until January 1st. Isn't that right?
Yes.
Yeah. So the crime itself was retrospective, but the earned time didn't start.
Told you, they don't get a true up. No.
Okay.
Yeah.
That's what I meant.
So that, I mean, that's a big issue. Do we want to continue to have it prospective? Do we want to bill at all? I mean, first, I guess the argument, but assuming you had a bill and we did this bill, should people who are sentenced after the effective date of the bill be subject to, or should they be able to earn good time, or shouldn't they, no matter what the crime?
No.
Unless the sentence is life without.
You want an answer?
Senator Baruth.
I would say yes. And that would be with the understanding that in making plea bargains, state's attorneys and others would communicate, victims' rights advocates would communicate the possibility for good time to reduce an offender's sentence. So we wouldn't have the problem that we've had with the victims who gave testimony where they believed their agreement with a state's attorney was being abrogated by the legislation we passed last year. So I think that is a way to make sure that the system retains this, whether you want to frame it as a humane piece of legislation or a practical one that helps us manage behavior in the system. I think those are both true. They're both reasons for me to support it going forward. And then that obviously leaves the question of what to do with people who are sentenced prior to the bill.
Other comments?
If Philip said what I think, which is that going forward, there would be no qualifying crimes.
No disqualifying.
I mean, no disqualifying crimes, then I agree with him.
I would love to hear from both the Attorney General's office, perhaps from the victims community on this one. Anybody who would like to weigh in, Flacco, Schilling, you're welcome to. Judge, state's attorneys, but maybe we start with the Attorney General.
Thank you, Senator. For the record, David Chair with the Vermont Attorney General's office. With respect to this issue of whether there should be any disqualifying crimes going forward, we would have no objection to the suggestion of Senator Baruth that we simply have all crimes be qualifying in the future. The reason for that is that I think the interests we're trying to embody, the heart of this bill, is really a notice and fairness issue. And making, let's for now state as a given that we believe that earned time is a good policy. What we're trying to correct here with this bill is a real unfairness and harm that resulted from not having fair notice to people who were victims or relatives of victims of very serious offenses in the past. We think that the bill, with its list of disqualifying crimes, helps correct that. But going forward, notice will be there because the law will be present. People who are being sentenced will understand that this is a possibility. Victims in cases will understand that this is a possibility. And we will include language, I believe, or there will be a proposal to include specific language about notice that prosecutors' offices will be required to give. So I think it makes sense to simply have it be for everybody going forward. And frankly, I also think it clarifies and simplifies the bill in a positive way to simply have the focus of this bill be correcting a mistake for those who I would say, you could argue a mistake in terms of fair notice for those in the past. Let's keep it simple, keep it focused on that. And going forward, everybody will have notice, and there's no need to have a separate petition process for any category of offenses. So we'd have no objection to that change.
Who'd like to speak next? Anybody? Flacco?
Yeah, thank you.
I'm Flacco.
Well, thank you for the opportunity to speak on this bill. We submitted in writing the testimony we provided earlier. And we have a general objection to moving forward with this bill in any form, having any disqualifying crimes. And based on that, we would, if this bill moves forward, would of course be supportive of making sure that anyone who is sentenced in the future be able to have the ability to earn time. One of the major objections that we raised to this piece of legislation comes from the reasoning provided by all the stakeholders in the Department of Corrections in their reports on the effectiveness of a good time program, where they came down very strongly in support of including everyone in this program, both because it makes it a more effective facility management tool, it makes it easier to incentivize good behavior from everyone within the facility, and then also there's the complications of administering a program where you have carve-outs, which we have heard was one of the reasons that previous programs got a little too unwieldy and unable to and end up being repealed. So just on this point, I think if this bill moves forward, it's important to include people who are sentenced in the future for all the reasons the Attorney General just stated.
Judge, did you want to comment?
Thank you. For the record, Brian Grierson, Chief Superior Judge. If moving the bill forward by eliminating the petition to the court at time of sentencing, I think makes a lot of sense. Leaving that procedure in there, I think, could lead to inconsistent results for similar offenses. And I think if good time or earned time is an effective tool for the Department of Corrections, then I don't think it makes sense under the circumstances to leave it to the discretion of an individual judge whether or not someone gets or is entitled to that earned time. And as I said in my earlier testimony, the process as it's outlined in the bill as introduced would result, I think, in certainly contested sentencings over that issue. And so I think by removing that petition process would make sense from the court's perspective.
Sarah Robinson, do you have a comment?
Yes, certainly. Certainly most of the witnesses that you all have heard from and most of the victims that we have heard from are victims of people who have already been sentenced. And their primary concern was really the lack of notice and their feeling that they had a promise from the state of Vermont about the length of sentence. So we would be comfortable with that sort of proposal moving forward as long as there was robust victim notification moving forward in all cases. And we have testified that we do feel like good time is good public policy. It's important to have incentives in place, and so we would be able to support that.
You provided some amendments to make sure that the victim notification would be clear how much time they might potentially earn.
I did, yes. In the underlying statute, it currently state's attorneys are required to inform victims of the existence of good time. And so our proposal would be to ensure that victims are informed of the maximum amount of good time that could be accrued in the sentence. So I sent that language to you, Senator Sears. Apologize, Eric, I didn't send it to you. I didn't copy you, but I just forwarded it to you.
I think I forwarded it to Peggy, so I don't remember now. I'm getting so many emails daily that it's hard to keep track of what I did. You got it now, Eric?
I did. Thank you. And thanks, Sarah.
Okay. Chris, did you have a comment?
Senator Sears, you mean me?
Yes. Chris
Yes,
Benno.
I do have a comment.
Okay.
For the record, Chris Benno with the Vermont Center for Crime Victim Services. I understand all of the fairness and how to manage large populations. However, I still would think that there were some crimes that would not, that it would be a fixed sentence, that in fact, time could not be earned. And in part so that even if at sentencing, the victims were told, okay, this is this, but if they earn this time, it could be that. I think that's confusing to victims. I mean, I think they would understand, but I think part of the understanding is, really? Like, why is your sentencing like this then? And I think victims really aren't that keen on the reasons why everyone should or could be involved in this, and that it's management, it's an incentive, it's how to control people. They're concerned, especially with violent crime, they're concerned that the person who harmed them is not going to be able to do that for some amount of time. And I do think it's kind of strange. I understand, and I do support the language that Sarah referred to. But it's odd, I guess, and I don't know how else to say it. It's odd that somebody who committed a very violent crime, when they're sentenced, the victim is told, okay, they're going to have 37 years. But if they earn this time off, then the sentence really is whatever the math would be, and I haven't done the math. I find that confusing. I think that's all I have to say about it. I just find it confusing. I understand why you would want to do that. It would be easier and management wise. But I would say that people who commit really violent crimes shouldn't be able to earn time off.
Others who would like to speak on this? Marshall?
Thank you, Senator. And I'll just start by, apologizing. Matt Valerio had to duck off to another hearing, so I've jumped in to fill in for Matt. We certainly would support ensuring that people are eligible for good time going forward or earned time going forward, regardless of the offense they've committed. When it comes to the idea that this would be confusing or somehow out of the ordinary, when it comes to victims' perceptions of these sentences, I think you don't need to look further than any of the many jurisdictions that already have a system like this, including the federal court system. The federal court system has a system of earned good time that's in a lot of ways similar to the system that we have in Vermont now. And that applies to all manner of very violent, very serious offenses. And that's been in place for many, many years, and it has not presented a problem. In fact, it's a very workable system in the federal system. And if anything, the system that we have in place is actually easier to understand than the federal system. The federal system has a few oddities around, minimum sentences, but for it, that our earned good time system doesn't have. So I think if anything, there's earned good time systems have been in place in other jurisdictions for a long time. They haven't presented a problem in terms of victims' understanding of the sentences or the administration of those systems. And if anything, this new system we have is simpler than the federal system, which is the most well-known of the earned good time systems. So with that, we certainly support the proposal to ensure that it is made applicable to everyone going forward.
Anybody else? I have a question on 2602, Eric. If we were to go with allowing earned time, in 2602, is there a problem there with the minimum of at least 10-year imprisonment or 5-year? Shall be served and may not be suspended, deferred, or served as supervised sentence. (2602)(c)(1).
Yes, I'm looking at the mandatory minimum there. It's an interesting question. I think that you're right. The question would be, would they not, would the good time only be available to reduce their earned time? Sorry, would the earned time only be available to reduce their sentence after the minimum had been served?
Right. I think it's pretty clear in that. And I actually, I remember when we wrote that under Act 1, 2010.
Yep.
Actually, I would hope that would remain. There was good reason to feel that there needed to be a minimum. It was other than murder, I think, was something else. It's the only place we put a mandatory minimum in.
Yeah, I think that you're covered by that second sentence, Senator Sears, too. It says the defendant shall not be eligible for probation, parole. So they're not going to be able to get the parole until the expiration of the minimum.
Yeah. Yes, Senator White.
I just wanted to, Judge Gerson mentioned the removing the section there about doing it at sentencing. And I just wanted to remind us that Matt Valerio also had that concern.
Well, we wouldn't meet it if you don't do it prospectively. You wouldn't need it. You wouldn't be petitioning. The individual would get it anyway, right?
Okay, I misunderstood. I thought the language said that they had to do it at the time of the.
Well, everybody would qualify, so you wouldn't.
Yeah, you would. The proposal is to strike that entire subdivision 6. It would be gone.
Right. Okay. Yeah. Yep. Okay.
I'm going to ask a question of those that do this all the time, the Defender General and the State's Attorney and maybe the Attorney General. If somebody knew that somebody was going to get, let's say they had a 20-year sentence for minimum sentence for first and second degree murder, 20 years and a maximum term of life, and they weren't sentenced to life without possibility of parole. You knew that they were going to get at least 20 years. Would you add on, when you're fashioning the sentence, enough time to make up for the good time? Would they then get a longer sentence?
For the record, James Pepper from the Department of State's Attorneys and Sheriffs. I don't believe, I know there's data out there. I don't believe that happened when earned good time was originally introduced. It might be a good thing to track moving forward, but there's nothing in this bill that would prevent that, except that to keep in mind that, you know, judges have to approve any plea deal or any, and then they're of course in charge of just open sentencing. So it's a possibility. It's one that we actually identified in our earned good time report as a potential possibility. But I don't think that historically there's data to support that. But you know, it's something that again would probably be a benefit for the legislature to know and track moving forward.
Marshall, any comment?
I think that the question is, there's no real way to answer it. I think it's speculative. I am 100% sure that there will be cases where either a prosecutor argues for a longer sentence, and part of that argument is based on the amount of the fact that the defendant is eligible to earn good time, or that a judge fashions a longer sentence and does so in part on the basis that the defendant is eligible to earn good time. And then I'm sure that in a lot of cases, hopefully a majority of cases, hopefully a vast majority of cases, that sentences will be handed down exactly the way that they are today, and that good time will have the effect that it's intended to have, which is to say that it's to provide an incentive, to provide a lower sentence in return for good behavior. But I think that it's, you know, I think you can be sure that there will be examples of people who are given longer sentences, or who at least longer sentences are argued for in order to account for the potential that they'll earn good time. But I don't think that that will be, it certainly won't be in every case, and hopefully not even in most cases.
So,
Yes, Judge Grierson.
Senator, I would just add to Marshall's comments that the committee should keep in mind that the Justice Reinvestment group found that I think it was 99%, 98, 99% of the cases are resolved through plea agreements. And those plea agreements then presented to the court are obviously fashioned by negotiations between the state and the defense. And so I think it would be hard to track the kind of question you've asked, but at the same time, there's not going to be that many cases where the court will have complete discretion in fashioning a sentence. I would say that in those, let's call it the 1 or 2% of cases where it's truly a contested sentencing, no agreement, if part of the if earned time is part of the equation, it would be taken into consideration, and to suggest that it wouldn't be would not be accurate. But I think the important thing is to remember that so many of these sentences are by agreement of the parties, and that's where the real negotiation will take place between the attorneys.
I'm mindful of Chris Benno's comments regarding the victims and how they might see this or perceive it. They've been the victim of an extremely violent crime. I believe all the disqualifying crimes are extremely violent, as I said, with that one exception that I pointed out. So I'm torn here. But with the Attorney General's recommendation, and I said from the beginning that I was carrying the Attorney General's water on this one. So I guess I would tend to go with the Attorney General. and support not going prospective.
And support what? I couldn't hear you.
And support the proposal that Senator Baruth made to not go, I think it was Senator Baruth, to have this, it solves a couple of problems. One is this idea that at sentencing, you could petition to have it. It was taken away. I can see that as a protracted battle. People would know about it up front. I would think we would add the language that the network Sarah Robinson provided to make sure that victims are well aware of what the potential good time is moving forward. I would be comfortable with Senator Baruth's motion.
So his suggestion, though, was just about prospective moving forward. We haven't
Yes.
talked about backwards yet.
Well,
Am I right?
if you don't do the go backward, then there is no reason for a bill.
Well, that's right.
Frankly, so
Right.
that's why I haven't. I mean, people may vote against the bill, obviously, but there wouldn't be a point of having the bill if we didn't do something about. I mean, that the outrage was that people who had already been sentenced were going to receive good time for very violent offenses, abominable offenses.
I guess.
And so that was the, that's the impetus of the bill. So.
Right. I guess my question is, even retrospectively, if we had any bill, I'm not sure that I would, and looking backwards, I'm not sure that I would agree that all of these 8 things should be disqualifying.
Well, okay. That I, okay, that could be the next subject, is what's qualifying crimes.
Didn't we?
If we've all agreed, Senator Nika voted no, I believe. But you're muted, Alice.
I voted no on the bill from last year.
Okay.
I'd like to fix it as I think this bill proposes, but going forward. So in other words, would those people that were previously sentenced still be earning time?
No. Other than for the period between now and the effective date of the bill. If the bill passes in its current form, people who are sentenced after, let's say it passes May 15th.
Yeah.
After May 15th, people that are sentenced would receive during good time, but everybody would be aware in fashioning that sentence that they were eligible for the earned time off. People who were sentenced prior to the effective date of the bill would not be eligible if they committed any of these crimes unless we decide not to include all of the crimes. So those that are sentenced prior to May 15th, if that's the date, would earn good time between January 1st and May 15th. We can't take that away. I think that's pretty much established. But you could, but going forward, they would not be eligible.
Going forward, they would not be eligible for
Those that were sentenced prior to May 15th. I'm using May 15th just as a date.
between January 1st and May 15th.
Right, they would earn it, and then after that, they would not earn it.
After May 15th, it would stop.
If this bill passed
Okay.
in its current form, which is that it's not available to those individuals.
Well, if I could.
I don't know the numbers, and I don't know that it's important to know. I don't think the numbers are that high.
Right.
But it may be higher than we think because we have moved an awful lot of people out of jail who committed crimes that are not in this category.
Okay.
Senator Bruce?
I was just going to say, what I hear Alice saying is she could support a bill that disqualified this list of crimes going forward, but wouldn't support the bill if it didn't disqualify those crimes going forward.
I have some flexibility there.
Oh,
As long as well, anyway.
As long as, I would say that the easiest way to look at this is we're not changing them, other than for a period of time between the January 1 and the effective date of the bill, we're not changing the rules of the game.
We're not changing the what?
Rules of the game. People were sentenced to 45 years to life. They would still serve the 45 years to life minus whatever they accumulated between January 1 and May 15th.
Okay.
So I think for some reason, I feel that we've gotten into the weeds somehow. And my understanding is that going forward, we are not going to have any disqualifying crimes.
Correct.
Everybody is eligible for earned time, and then they will appeal at that point in time, and then the parole board or whoever will determine whether they get it or not.
Right.
They're not
Right.
eligible, but they're not
It only,
guaranteed.
yeah. It
Okay, so we
reduces
made
their
that-
minimum, but they still have to go through the parole. They can still
Right,
be
right.
rejected.
Right. So we've made that decision. And then there's the decision about the last year when we passed it, everybody was also eligible. But this bill makes some people ineligible in the past who were convicted in the past. I would like us to talk about which crimes should be on that disqualifying list for going backwards. Because I don't see that some of these make any sense, but so, because I can't support a bill that has
we
all
did have
qualifying crimes.
We did
for-
have a discussion last time where it seemed to me we did a straw vote on a couple of them.
Yeah.
Like the arson charge, I thought there was agreement to get rid of that.
Yep. Manslaughter.
Yeah. I don't know, Mr. Chair, if you want to formalize those votes now, but
We could. I'm going to leave in 20 minutes. Just so you know. Yeah, we could. I mean, I think there's general agreement. Was it arson causing death?
yeah.
Yeah.
One, and voluntary manslaughter.
And involuntary.
They had both voluntary and involuntary in there as
Somebody's dead.
it's too bad.
Okay. All right. So those two we've agreed to.
Agreed to, want me to reiterate what I have in my notes, Senator Sears?
Yeah, please.
We had gotten through the first four on the list.
Yep.
And what I have in my notes is that the committee decided to strike number 1, arson causing death, to include murder, number 2.
Yep.
To strike manslaughter, number 3, to include kidnapping, number 4.
Yep.
And we were on number 5, L&L with the child, when the committee time expired last time.
And I would propose keeping L&L with a child with the exception that those who would not be on the sex offender registry under A2, 2602A2, not be included. That group, that small window that we created for the sex offender registry way back in Act 1.
I'm good with that.
So what are the age difference? What is that range?
I can read it to you right now if you want to hear it.
Yeah.
It is if the perpetrator is under the age of 18 and the victim is at least 12.
And the sex was consensual.
Yes, thank you, Senator Sears, right.
So it was a 15-year-old.
Well, conduct was conduct. A 14-year-old and a 17-year-old. It's the exact, we debated this at length and decided it was part of the compromise that led to Act 1, where the House refused to go to 14 or 13, I can't remember which. Senate had passed it.
I'm having a hard time hearing you, Senator Sears. I don't know.
The Senate had passed a larger age gap. Can you hear me now?
Yeah.
And the House objected to anybody under 15. So when we did the sex offender registry requirements, we changed that for a certain subgroup of those who were under 18 and the victim was over 12. That was part of the compromise. All I'm suggesting here is if somebody is actually, I don't even know if there's anybody even convicted on that. But if somebody's actually incarcerated on that they be able to earn good time. If we decide they didn't need to be on the sex offender register.
Right.
That makes sense to me.
Okay.
And then would leave the rest of 2602 intact.
Correct.
Is that agreeable to everybody?
I'll agree to it. I don't like it, but I mean, I just, I'm not sure we should be incarcerating kids, but.
It may be that I'm on my 4th Zoom conference right now, and that's why I'm willing to agree with Philip, because otherwise we'd probably be in disagreement.
Maybe that's my case too.
I like the way the implication that no one in their right mind could agree with me.
I want to jump over sexual assault, go to aggravated sexual assault. Is there any problem with aggravated sexual assault being involved in there?
Well, I personally would like to have no disqualifying. So just in the spirit of compromise, I'm going along with some of them, but I would like to have no disqualifying, even in the past, because I don't think
We're only doing retroactive. So
I know.
Aggravated sexual assault of a child, I believe should be included.
I agree.
I agree.
Yeah, okay.
And then we come to the only one outstanding is 3252 sexual assault.
And can Eric read the definition of that?
I don't know if anybody hears that, but we have a dog with pneumonia we're dog sitting for, and she's got a terrible cough. So you might have heard her just now. She's doing okay. She's on antibiotics, so she's hanging in there. But the sexual assault is only, you'll see this is subdivision.
There it is.
There you go. There she is. She's doing okay. It sounds worse than it is. The subdivision 6 is the sexual assault one. You see, it's only 2 parts of the sexual assault statute that are listed here, A and B, and that's so the intent of that is not to include any portions of the sexual assault statute where it's based on age, sort of the statutory rape situation, to use sort of shorthand language that I know isn't necessarily the way we refer to it now, but just for the sake of brevity. So it only includes A and B, which means it's only situations where you can see, if you want to look at the language in the handout, it's either based on lack of consent, threat or coercion, or placing the other person in fear that they'll suffer imminent bodily injury, or, and this is, I'm moving on to B now, impairing the ability of the person to appraise or control conduct by administering or employing drugs or intoxicants without their knowledge or against their will. So it's only those situations of sexual assault that would be covered here. Anything else that's based on age or the sort of caretaking relationship between the two people, which are other variants of sexual assault, are not included within the ones that would be disqualifying offenses. It has to be a situation where there's lack of consent, threat or coercion, placing the person in fear of imminent bodily injury, or essentially using drugs or alcohol to deprive them the ability to consent. So those categories are carved out for purposes of the disqualifying offense. That's the proposal anyway.
They're carved out, meaning this
behavior would be disqualified from earned time.
I'm okay with that.
I'm okay with it.
I'm okay with it.
Well, I think we've completed the qualifying crimes. There was a letter from some group about another crime they wanted added, but I don't have that available right now. With all my darn files.
I think we all got it.
I'm going to so we're changing the name to earned time, notwithstanding 1 VSA 2014. We got the age gap. We're going to have language on compassionate relief for the next time we take it up, Eric.
Yeah, I just got that from Bryn just now. I emailed her.
Okay. And Monica Weber's language regarding, and Sarah Robinson's regarding notices.
Yep, got those two.
Monica's is the language regarding interrupted sentences.
Yep.
Okay. Is there anything else that I've missed that we're going to look at tomorrow?
Well, just you're going to strike the whole piece about applying to future court cases, that whole subdivision 6.
Except that there will be something about the notice to the victims, correct?
Yes, exactly. I think that's it. That's what I have.
And we're scheduled to take this up again at 10:45 on tomorrow.
Tomorrow at 10:45.
Yep. Do you want to continue to discuss this, or I don't know that we've got anything to discuss at this point. I realize I'm trying to get out of here to get my teeth cleaned, but
This isn't.
Senator White.
This isn't on that, but the Department of Health got me a COVID vaccine appointment for tomorrow at 9:20 in Grace Cottage. So I will be gone for a period of time.
Okay, well, thanks for letting us know. I had mine yesterday. It was relatively painless, but I wasn't able to make a public hearing.
Why isn't Alice getting hers?
Too young.
She's too young.
Okay.
No, I'm getting one
She's a youngster.
Okay.
Friday afternoon.
Just want to make sure we're all
after
covered.
this is over, we'll have a discussion about Kinney drugs.
Oh.
And the state
Or
making
Walgreens.
deals with Kinney drugs. Well, it's the federal government that's doing the Walgreens, but it's the state making deals with Kinney drugs when they're not available statewide. I don't know that the state even knew that.
They didn't.
Or Bennington and Windham and Windsor counties and Rutland counties get left out again.
Yeah, but we have places down here now.
We do.
Mhm.
That's only because you spoke up, Senator. Hey,
We
have a
met with
great,
We met with
Huh?
Dr. Levine, our delegation did,
we did too.
and you got more places.
But yeah. Well, enjoy the day. Thank you all very much. We'll pick up here tomorrow on this bill at 10:45. Hopefully Senator White will be back.